Dear colleagues, good morning or good afternoon, depending where in the world you are. Thank you very much for joining the second and the expanded session of our Global Transitional Justice Dialogues. My name is Katerina Busol. I'm a legal associate with the International Center for Transitional Justice and the associate professor with the Kyiv-Mohyla Academy. So having an honor to be partnering with 4 of our co-partners in this webinar series organized jointly by the ICTJ, the Ukrainian Bar Association, the Kyiv-Mohyla Academy Law School, and Truth Hounds. Today we will be speaking about the intersection and the mutual nourishment of domestic, regional, and international justice initiatives, with a particular focus on Colombia, Sudan, and my native Ukraine. I give the floor back to my co-moderator Inna Vinova, and then we will be opening the discussion with our 4 remarkable speakers. Inna, over to you.
Thank you, Katerina. Thank you to all I would like to also welcome and thank all the participants of today's event, and also participants who are probably watching us in recording. Today's event is indeed a very important, and this series of events that we, together with our partners, launched on transitional justice, we believe is aimed at feeding more information about transitional justice, best practices, lessons learned, some food for thought to Ukrainian counterparts, partners, so that we could develop policy, legislation, and practices that support victims affected by the war in Ukraine. Today's topic is of particular importance to Ukraine, which, unlike in other countries, in other cases, already actively started criminal investigations into international crimes committed in Ukraine. If you look at the website of the Office of the Prosecutor General of Ukraine, more than 190,000 proceedings were initiated under war crimes. And it doesn't include crimes against humanity, genocide, which also take place. Probably 99% of these of all the investigations in Ukraine will take place at the national level. The ICC certainly goes ahead with proceedings. However, the status of an international institution prohibits ICC from launching more investigations. I would also hope that today we maybe discuss or maybe start thinking about the positive complementarity principle, which evolved in the international law and encourages national jurisdictions to adopt a hands-on approach and go ahead with proceedings at the national level. As a Ukrainian and on behalf of the Ukrainian Bar Association, we also encourage Ukrainian counterparts, but also especially national law enforcement authorities in other countries to also look into universal jurisdiction and apply universal jurisdiction more actively, so that to support Ukrainian investigations at the national level, because national jurisdictions in other countries, by using their time, resources, could significantly advance investigation in those important areas. I would also like to thank co-organizers of today's event, our partners, the International Center for Transitional Justice, Kyiv-Mohyla Academy, and Truth Hounds, for supporting this initiative with a series of webinars. And I would like to invite all the participants of today's event to follow us, because after today's event, certainly more is to come. But now, Katerina, the microphone is over to you for further introductions.
Thank you very much, Ina, and colleagues, just a kind reminder that the translation is available, so please use the button at the bottom of your screen with the globe to see whether you'd like to listen to the webinar in English or in Ukrainian. And just for those who are speaking, and mostly also to myself, we should try and speak at a slower pace so that the interpreters also capture all the nuances of the presentations. And colleagues in the audience, you're very welcome to put the questions in the Q&A chat so that after the 10-minute interventions from each of the speakers, we could turn to a more interactive discussion. And here I turn to introducing our marvelous participants today in an alphabetical order. We're very grateful to have Mr. Yuri Belousov, who was the former head of the War Crimes Unit in Ukraine with the Office of the Prosecutor General. And Yuri's work has been exceptional because he led the War Crimes Unit since before the full-scale invasion and in the crucial years of the full-scale invasion. Then we are grateful to have Dmytro Koval, who is the co-executive director at Truth Hounds and an associate professor and the dean of the International Law Department of the National University of Kyiv-Mohyla Academy. Truth Hounds is the leading Ukrainian NGO working on Russia's atrocity crimes since the beginning of the aggression in 2014, as well as working in the number of other jurisdictions on international crimes, as well as on grave human rights violations. So we'll be very grateful to hear Dmytro's perspective on how the civil society contributed not only to the documentation of the atrocity crimes in Ukraine, but in shaping the state and international partners' sometimes vision on how these crimes should be addressed and redressed, not only through prosecutions. And then we are very grateful to have Ilaria Martorelli, who is the head of Sudan program at the International Center for Transitional Justice. Ilaria works with a large number of actors in this context, and naturally, very recently, we have seen an important ruling coming from the International Criminal Court, and it will be so important to hear how the survivors of this protracted and very complicated context have perceived that ruling and whether it renders certain meaning of justice to them. And finally, last but not least, Maria Camila Moreno Munera, who is the head of Colombia office at the International Center for Transitional Justice. And we refer to Colombia so much with its groundbreaking special jurisdiction for peace, with its inclusion of the transitional justice lens in the peace process already, and most recently in seeing the first judgments coming from the special jurisdiction for peace. So it will be a unique opportunity to hear from Maria as to how these measures also are perceived domestically and how the elaboration of transitional justice response in Colombia domestically has interplayed with its engagement or disengagement with international justice actors. I think we could start with our alphabetical order by means of introduction. So then, Yuri, if you don't mind, the first set of 10-minute interventions, over to you.
Dear Katerina, thank you so much. Dear colleagues, dear participants, it's a great pleasure for me to be here and to share with you the Ukrainians' experience. And the last months, I'm only working for another institution, but still, war crimes and everything related to this, I think, will stay to the end of my life with this definitely. That's why thanks a lot for the invitation. Let me briefly discuss. I just make my speech in several blocks, and let me start with the first one. I would try to present it from the side of national system of investigation and prosecution of war crimes, because I think this experience could be, unfortunately or fortunately, useful for other countries which are facing the same challenges, and it's definitely better to study international experience, which could be relevant to national context of other countries. As to the Ukraine, so we all know that the Ukraine started in 2014, but definitely much smaller scale. And at that time, the part of Ukraine was occupied in eastern part, in Crimea, and the national system started to react by establishing a small unit of prosecutors who were focusing on investigation of this type of crime. But since 2022, after the full-scale invasion, the scope of violations of humanitarian law was increased dramatically, and it became obvious for us that this small unit is not enough to deal with such a great number of terrible cases which started to be related to the war crimes. And as to the national system, sure, we faced all the challenges possible because we didn't have people enough focusing on war crimes. We didn't have knowledge of international humanitarian law, and we didn't have effective cooperation inside of the country and with other international partners. And all these challenges from the very beginning. One more challenge maybe, which became obvious with such a big challenge, that the Ukrainian criminal justice system, was a bit old-fashioned ones, which get used to paperwork, which get used to physical contacts with people whom you're working with, but different technologies and innovations in terms of the criminal justice system, wasn't much a priority before full-scale invasion, because people get used to some modus operandi in different types of investigations. And again, so they were pretty comfortable maybe with these types and these approaches to the investigation. But when we had such a totally new sphere, which we didn't have again enough expertise in, we had to study on the way and to change in a much faster way than it's happening during the peaceful time, just to be able to at least document what is happening around. At that time, we didn't think much, first days on the effective prosecution. The main task was to fix everything, not to lose evidences. You all know about these videos and photos from Bucha. It was maybe the first most, challenging case which Ukrainian criminal justice faced after liberation of Kyiv region, when we all see what kind of atrocities could happen on a pretty small territory. And then we understood that such Buchas are pretty widespread in other parts of our country. And based on these challenges, we started to build a national system. And here it's extremely important that the cooperation between state and civil society, because we all also know that pretty often in peaceful time it could be different because of the civil society role is to keep state in the proper shape, not to violate human rights and to perform properly the function. That's pretty often is two sides of the barricade in peaceful time. But here we opened in a situation where there's a third party, there's an enemy who came to our country and who started to kill and to rape and to steal our people and bring them abroad. And that's why civil society and state started to effectively cooperate from the first days. It was extremely important for us because civil society and organizations which were documenting war crimes that had much more expertise in IHL, which was extremely useful for us in these first days. It's also important that almost from the first days, there was a decision to invite international experts who had expertise in prosecuting international crimes in other jurisdictions, in other tribunals. In the Office of the Prosecutor General, almost in the first days of the full-scale invasion, there was established a special coordination, body comprised of international experts, prosecutors, investigators, and judges who had this expertise, who immediately started to work with the national prosecutors to help them to do their job better. How we started to build a national system? First, we understood that there is a great need for specialization. If we have a prosecutor and investigator who investigate, in addition to war crimes, other crimes, he or she would never be effective, in all these different types. That's why we decided to have a special unit in the prosecutor office And then we started to establish regional teams, because regional teams are always closer to the front line. They have, first-hand information, and having these people on the ground significantly increase our efficiency. It took some time to establish these special units in the prosecution office, and then we started to persuade our partners from National Police and Security Service who have investigators that they also should have a specialization on that. And that was, how to say, like a skeleton of a national state system of the prosecution when we started to work three agencies, prosecutors, National Police and Security Service working together to effectively document and collect evidences of war crimes. Sure, the second step, what we also faced, is inefficient cooperation between different actors, especially state actors, who each institution has its own interests, has its own databases, has its own information, not always ready to share. And it took us time. If we should have a system, we shouldn't just have institutions as a skeleton. We should have very effective internal connections between different institutions. It also took time, but in the long run, we understood that we are wasting a lot of resources, let's say even more resources, on arguing with each other and establishing coordination than investigation itself. That's why, in order to save our resources and to fully focus on documenting, we had to build these internal connections and between different institutions. The next stage, where again we really appreciate the help of civil society with the national standards, we understood that we should speak the same language, all of us who are documenting and prosecuting war crimes. We understood that we need standards, which we all take as a Bible, let's say, which we don't argue about. We just take it and go and document using the same terms, the same logic. That's why we started to design standards for investigation, and taking into account the huge variety of war crimes. It took us time and it's still an ongoing process to design standards which we share between investigators and prosecutors, and it also helped us to save significantly resources. The one more point which is extremely important, and we also faced, that traditional ways of investigation doesn't work in extremely difficult context. It's good for maybe for peaceful time when you don't have many cases. You could use traditional, old-fashioned styles. But when each of our investigators at some time had around 500 up to 1,000 and now more than 2,000 cases per person, we understood that without innovations we just can't do our job. And again, we really appreciate that Ukraine was given a lot of support from our international partners who gave different technologies which already been proven in other jurisdictions to Ukraine, not to design it its own, but already to use and adopt ready ones. Sure, it's two different issues, to take what is ready and adopt it, but in parallel to work on designing your own system which fully fits your national context. And this support helped us a lot. As an example, I could mention one of American company which provided us with drones, which helped us to fix damages, let's say, especially when the huge view. There were a lot of famous cases, unfortunately, like a drama theater in Chernihiv, for example, when the rocket killed a lot of people and fully damaged the building. To fix these damages for the future court in traditional, let's say, ways, it would take several days just to fix it. With the use of drones, it took us around 1 hour. Within 1 hour, the drone made up to 2,000 pictures during 1 hour from different angles, and then reconstructed the 3D model of this damaged theater, which was rebuilt in a year. But the damage was fixed for us, and we could use it in a court, both in national and international court. A lot of other analytical tools which help us, and again, OSINT instruments, they helped us a lot, because when you don't have access to the territory, in traditional investigations, it means that you should stop your investigation, because just you don't have access, so you can't collect evidence on the ground. The OSINT investigation helped us a lot to collect evidences when you don't have a physical access to the territory, which again, innovations is something which really helped to survive in totally different contexts which you didn't get used to. International cooperation. I should mention that from the first days, and here I would reflect on several issues, there was a joint investigation team was established, and 7 countries joined this joint investigation team, and the idea was not to lose evidences with statements from Ukrainian refugees who leave Ukraine, because several million people left Ukraine, and sure we were afraid that a lot of them are witnesses which could take the information out of the country and we would never know what's happening. And it's still a problem because such a great number of people which left at the time Ukraine, a lot of them came back. But with the help of joint investigation team, with the help of our NGOs, our partners who work with our refugees, a lot of information was collected and is still being collected. International Criminal Court, sure, it's one of our biggest and greatest partner who also came to Ukraine and started to help us to collect evidences. And honestly speaking, I used the ICC reputation, let's say, and strengths to persuade our colleagues inside of the country that the quality of investigations should be very high. Because, it's not about me. It's ICC would come and see your case, and it would be shame for you and for Ukraine in general that the evidence is such a not a very high quality. We agreed then with ICC that I'm using sometimes the brand, but it was for the sake of justice, I think, because maybe when I meant challenges, one of the biggest challenges was a mindset, because when you face enemies, so it's always chance, high risk that you could lower standards of investigation, because it's obvious enemy who come to your house, who kill your neighbor, maybe relatives, and you should use the rule of law standards on the highest level to document it. Now, from moral perspective, and a lot of our investigators and prosecutors didn't understand it in the beginning. But we explained that we are different from our enemy. We shouldn't focus on their standards. We should focus on standards of EU if you want to be a part, and we should prove that even in the wartime, even because of its EU enemy, your standards should be even higher than in the peaceful time. And it really took us time, but I believe that because of such approach of our colleagues, so we raised the quality for pretty high standards. Universal jurisdiction, it's also an issue. Taking into account the volume of evidences and the scale of atrocities we had to document, honestly speaking, we didn't consider, in a year, we stopped considering universal jurisdiction as something which would significantly help us with resources. I think it's about different task. We understood that we need universal jurisdiction for another purpose, not to help us, because when you have 200,000 cases, 1 or 2, 3, 5, 10, 100 cases doesn't save your life, let's say, as investigator and prosecutor. What it could do is to show that the world cares what's happening. And other countries support what is happening. And other countries make a decision about, make a critical analysis of what's happening. That's why the verdicts are so important, because Ukraine would always be criticized that we are part of the conflict. We are very subjective, let's say. That's why, in addition to ICC, we need other countries from a democratic world, which also in their jurisdiction would prove the fact that the war crime took place. From this perspective, we met several times and we still, our colleagues working on Eurojust platform. Everyone knows about Europol, but Eurojust is much less been known, which unites prosecutors from EU countries and some other countries which work on war crimes. And we explained the guys that we are ready to give you all evidences we have if you would prosecute in your court. And Finland might be one of the best examples when it already led to results, because the guy was arrested on data and they didn't have much evidence against him, but we had. And we asked him, could you deport? No, they refused to deport him, but said, okay, we could proceed if you help us with evidences. And the investigators came to Ukraine. We gave them a lot of, in a formal way, sure, all evidences. We transformed a lot of evidences from Ukraine, which led to such a result. But now Ukraine could say, look, it's not just about Ukrainian court, it's a Finnish court, look. And other courts, actually, a lot of other countries in their jurisdiction, they have these investigations. And that's why universal jurisdiction for Ukraine is extremely important, because it's like an umbrella of justice. Because very often we think just about international institution, which from my perspective is significantly narrowing of the problem. We even went far because we see that a lot of national courts have a very good developed practice on international crimes, sometimes more developed than international courts. Because in international, I don't want to abuse international courts. I really like these colleagues and really appreciate them. But a lot of very interesting cases on genocide in Germany, in Sweden, which could be fully applicable to Ukrainian context. They have more cases on genocide than international tribunals have. That's why, from my perspective, it's extremely important not to think that it's like a second hand or second place when we talk about national jurisdiction. No, national jurisdiction has a huge potential which has to be taken into account. That's why working with universal jurisdiction is so important. And the last point I wanted to say when we talk about the international crimes, it's not just about prosecution. Prosecution is just a part of all this idea. We definitely need, with the help of international criminal justice instruments as well, to fix what was happening on our land in a specific period of time. We need to fix it. In a time, our children, our grandchildren, historians, researchers would take this data and they would make these decisions and reports, whatever, what was happening, not to forget what was happening. It's about memorialization. It's not just about prosecution. That's why it's also important that, the trust to evidences and to information collected within the criminal investigation sometimes could be higher than in other instruments. That's why when we talk about international crimes, this aspect always has to be taken into account. And with this, let me stop. I don't know if I managed to take 10 minutes or more, looks like not. And that would be great to answer any questions you may have. We'll try at least. Yeah, thank you.
Thank you, Yuri. Thank you for lifting the veil and sharing a very interesting information about behind the scenes processes and some issues that the national system faces. I personally have a lot of follow-up questions, but I will save them until all our speakers will have an opportunity to share. And while using this opportunity, I also wanted to invite participants of today's webinar who are with us online. If you have questions, please start sending them in the chat and we will do our best to respond to all of them. And now I would like to give the floor to Dmytro. Dmytro, please go ahead. We would be grateful for your perspective of working with truth hounds, but not only as to how investigations at the national and international level operate.
Thank you very much, Inna and Katerina. Since it's the first time I'm taking part in the webinar, I just want to say thank you for coming up with this idea of webinars on transitional justice, the webinar that, from my perspective, very in a very good way combine practice with theory, academic knowledge with the field experience. So really grateful, and we at Truth Hounds and Kyiv Mohyla Academy are really happy to be part of the series from starting from this webinar. So not to overwhelm the audience with the information about Ukraine, I will try to limit myself to some 5-7 minutes. And I will just add a couple of things because Yuri indeed pierced the veil in a very good way, showing how these mechanics of accountability efforts, both on the international level and on domestic level, work. And I will add just a couple of contextual points that, from our perspective, are relevant for the discussion about transitional justice, but also different forms of accountability and the Ukrainian take on them. So first of all, I would say that the way the case arrives to the ICC in many respects determines the dynamics around the situation in the ICC, but also domestically. So just a reminder that Ukraine was not a party to the Rome Statute for many years when the examination of the situation in Ukraine was already being done by the ICC OTP. And only 7 years, not even 7, 9 years after the ICC started first to examine the situation with alleged war crimes in Ukraine, Ukraine ratified Rome Statute. So that led to the quite a peculiar situation in which the ICC had the jurisdiction, but the decision had to be made by the prosecutors to go with full-fledged investigation. And therefore, the resources, in terms of resources, the ICC OTP had to be kind of selective and very reasonable with how it invests into the Ukrainian investigation. And that in itself and that impacted the quite an interesting dynamics between the International Criminal Court and Ukraine, in which International Criminal Court indeed did some first steps in examining the situation, but never crossed the line to the full-fledged investigation. And that motivated in many respects Ukrainian authorities and different other Ukrainian stakeholders, including governmental organizations and academia, to develop their own muscles to tackle international crimes, including war crimes. So basically, something that Katerina started with, that Yuri led the war crimes department even before 2022, is one of the illustrations of this growing of muscles, domestic muscles on the Ukrainian side. Exactly because the ICC was not fully available for Ukrainian survivors, but also because Ukraine's point its own responsibility for bringing the cases forward and properly documenting and addressing international crimes through domestic prosecutions. So when I'm speaking about the muscles that Ukraine was growing, I mean several things. First of all, the domestic expertise. I would say that Ukrainian academia, different Ukrainian universities, including Kyiv-Mohyla, maybe first of all Kyiv-Mohyla Academy, started to develop courses that dealt with transitional justice. Katerina led such a course in Kyiv-Mohyla, for instance. International criminal law and international humanitarian law, different aspects of these two fields of knowledge. So the academia responded by preparing new fresh blood for this accountability work with IHL, ICL, TJ issues. The civil society also responded by creating specialized programs of documenting, of training prosecutors, of developing capacity of different other Ukrainian institutions that was supposed to deal with the atrocity crimes, etc. On the prosecutorial and investigatory side, also, the special department was created before 2022 as one of the elements of this process of positive complementarity. Investigators also had the unit focused on international crimes investigations prior 2022. So what I'm saying is the dynamics around the bringing of the situation to the ICC, meaning that Ukraine had to recognize the jurisdiction and the prosecutor had to conduct the proprio motu examination of the situation, and after that decide whether there is a reason to open the full-fledged investigation, actually contributed and fueled this positive complementarity and the processes inside Ukraine. Positive complementarity, at least right now, if you Google it, will come up as part of the news stories about Karim Khan discussing Colombia and Colombian unique experience with special jurisdiction for peace, and basically how Colombia was able to domestically deal with some crimes that ICC considered to investigate on the international with its international tools. But apart from that discussion, I think another relevant discussion is Ukraine prior to 2022. And I do recall that somewhere in that period when Ukraine was under examination, the situation in Ukraine was under examination, Fatou Bensouda, previous prosecutor, also reflected on positive complementarity, and her reflection was that the ICC works even without having, investigating fully cases by the institution itself. It also walks through the positive complementarity, and maybe even it's a good sign that ICC does not have cases from some countries, because it stimulates those countries to think about innovative solutions, ingenious solutions on how to address the needs of survivors, but also how to go into this accountability track, criminal accountability included, and deal with crimes committed in certain areas. And I would say that Ukraine was, to some extent, a good example of that positive complementarity. I have many other things to add on UJ and on survivors' need and survivors' perspective, but I think that we can postpone this to the Q&A session, because I'm sure that each of the participants will further reflect on those areas, and I think it will be good to compare our notes and see how these similarities, what is similar between our contexts. So I will stop here. Thank you.
Thank you very much, Dmytro. Ilaria, we would like now to proceed with your comments on Sudan and on the perception of victims, survivors, and persons just affected by such a protracted situation and hostilities on the recent judgment of the ICC, and whether they're also seeing other redress measures as perhaps more viable for them. Over to you, Ilaria.
Thank you, and thank you for the opportunity to speak about Sudan. I will speak slowly to facilitate the task of our interpreters. So today, I would like to focus my remarks on two main developments that in the span of 20 days, they have profoundly shaped the lives of millions of victims in Sudan. These are two events that took place in October, and they're very significant. They both focus on Darfur, but in fact, they tell the story of the whole country, which is marked by recurrent cycles of violent conflicts, but also a relentless fight for justice. So the first is indeed the ruling by the International Criminal Court, which was issued on October 6th, when the ICC found that Ali Mohammed Ali Abdurrahman, also known as Ali Kushaib, was guilty of 27 counts of crimes against humanity and war crimes. These are atrocities that were committed in Darfur between 2003 and 2004, when he led the infamous Janjaweed Arab militias. The judges found that he was responsible for murder, torture, rape, persecution, and attacks on civilians. The verdict was unanimous, and of course, it was historic. It is the first of 6 Darfur cases before the ICC to reach trial. It is also the first case ever referred by the UN Security Council to result in a conviction. And it is also ICC's first conviction for gender-based persecution. Clearly, the judgment has profound value. It validates the suffering of millions of Sudanese that for 2 decades have been demanding recognition. It also tells survivors that the world is hearing them, and that even if justice took so long to materialize. However, just 20 days later, so on 26th of October, another event reminded us of the complexity of the situation in Sudan and the ramification of what has been total impunity, at least until the judgment of the ICC. So after a brutal 18-month siege, the Rapid Support Forces, or RSF, which are essentially the rebranding of the same Janjaweed militia that Ali Kushaib was leading in Darfur 20 years ago, they captured El Fasher, which is the capital of North Darfur. Since then, we have been receiving reports of summary executions, of ethnically motivated attacks, sexual violence on a massive scale. Evidence of mass killings are visible from satellite imagery and also from videos that the same RSF are posting on social media to terrorize the population. Thousands are believed dead. Of course, we don't have the accurate death toll because there are no journalists present and there is no staff that is able to make that determination. Militarily, this means that the RSF now control all 5 capitals of Darfur, which is a very vast region. And so they can exert control on an area that could be their basis for forming a parallel government, as they have expressed the willingness to do. And this, of course, would make the peace process much more complicated. For civilians, this is a nightmare without any end in sight. Famine has been already declared in over a dozen of areas. And for the second time in 20 years, echoes of genocide are surfacing again. The atrocity in El Fasher proved that the root causes of violence and injustice in Sudan have remained fundamentally the same. It's history that it's repeating itself. This is the result of a pattern of violence, and that was perpetrated in total impunity again until the ICC ruling. These 2 moments, though, they tell, so the conviction of Ali Kushayb, but also these renewed atrocities, they are 2 faces of the same one story. And that story is the commitment of victims to achieve justice and their courage to go all the way, despite the security threat that they're facing, despite the intergenerational trauma. There are entire generations that have they only know war. And also despite the immense humanitarian needs that they're facing. They are documenting, testifying, and engaging in any process that will bring them closer to the justice that they want to see. The conviction of Ali Kushayb would have never been possible without victims. 1,591 of them participated in the trial. They participated in the proceedings. For them, justice is peace. And it's for that they want to reclaim their dignity. And this is what will allow them also to reimagine returning to what their ancestral land, because what is happening is also an attempt to change the demographic landscape in Darfur. And this has been ongoing for the past 20 years, because essentially violence has never stopped in Darfur. So what potential does the ICC ruling hold for survivors? First, it sends a clear message of accountability. It warns every actor of the current conflict that such crimes will not go unpunished. Second, it may shift the political calculus of Sudanese leaders and potentially also their behavior, showing that impunity can no longer be taken for granted. Third, it opens a path for reparations, which is a legal right for victims to seek the redress for the physical and also emotional wounds that they are suffering from. Fourth, which is also very interesting, the process itself has been very educational and empowering for victims. In 2024, ICDJ accompanied victims, Sudanese victims, to the ICC to witness the closing statements of the trial. For them, of course, seeing Ali Kushayb, the same person that has perpetrated crimes in front of them, has been, and also seeing his attitude, he was really showing no emotion, has been extremely hard. But what they appreciated is the fairness of the process. And after initial misunderstandings about the role of the legal counsel, which they initially understood that someone was there to ensure impunity, they understood the logic. And in fact, they said that this is the type of trial that they would like to see in their own country once the war is over. And this is really a testament to their genuine attachment to real justice. It's not vengeance. They really want fair justice, the one that brings long-lasting effect. And finally, the ICC's work has also highlighted the importance of providing mental health and psychosocial support to victims and witnesses. All those who have engaged in the process were received support in different forms, depending on the risk that they were facing because of their collaboration with the proceedings. However, despite this important symbolic weight of this conviction, this remains an isolated act of justice. Other ICC arrest warrants remain non-implemented. Let's not forget the most important one against former President Omar al-Bashir, who was indicted also for genocide in addition to war crimes and crimes against humanity. He was the first sitting head of state to be indicted by the ICC. But there are others also that have been indicted, and due to lack of cooperation domestically, but also by state parties, that arrest has never taken place. The point is that Sudan's justice system is not ready to hold fair trials. Simply, there is no political will because there has been not a proper transition. There has been a short-lived experience of transition between 2019 and 2021 until the military staged yet another one of the many military coups in the country. But those 2 years were not enough to undo the damage of what is essentially state capture at every level. So there is no political will, there is no security to hold those trials, there are no reform institutions, judges, police officers, there are no legal reforms. Certain crimes are not even defined domestically as such. So without the cooperation of ICC state parties and without sustained international pressure, the promise of justice for Sudanese risk fading once more. But there are many lessons that can be drawn from the past. We have seen this before. After a cycle of violence, Sudan engages in peace processes, but they have failed in the past because, first of all, they were not comprehensive enough. There were no well-designed transitional justice measures that could really address the root causes of the conflict and the fundamental injustice at a different level that has been at the root of this repeated crisis, but also because these processes have systematically excluded victims, and in particular women. And we know that from peace process, from statistics, that when women are meaningfully engaged in peace processes, those peace processes usually last longer and have more meaningful impact. Also, these peace processes have been the result of elite bargaining, and they have ignored the need for truth-seeking institutional reforms and reparations. Again, during the short-lived transition in Sudan between 2019 and 2021, there have been peace agreements that were signed. There were provisions about transitional justice. There were efforts that were initiated, but the learning curve was long, and the threat posed by members of the former regime were so pressing that civilian leaders who have worked tirelessly, often unpaid, they didn't have the time to lead this process and to gain the knowledge necessary to design those reforms. So what comes next? In Sudan at the moment, we have 14 million displaced, both internally and externally. It is the largest displacement crisis in the world. It is the largest humanitarian crisis in the world. As I said, there are entire generations that have known nothing but war. But despite that, survivors continue to document violations. Very recently, we worked with them also to understand how to do open sources investigations. And these videos that are being posted by the same RSF will also provide useful information for those investigations, and as we do the satellite images. So survivors get together, try to have those hard conversations because they also need time. They never had a conversation about what it means to be Sudanese in a country that is so diverse, and they're really sure that justice is what they want. They're not passive, far from it. They are laying the groundwork for the future justice system that they can truly call their own. So of course we're working in the meantime to together to provide a space for them to discuss what a transitional justice process should look like for them. Even in the absence of an institutional-led process, there is a lot that civilians can do, and they are committing to those efforts in a way that is really, really touching. They are preparing hard for that. To conclude, it is very sad to see that there is little attention to the plight of Sudanese, despite the gravity of what is happening. And also, probably this is driven by a misunderstanding about the situation, which is not a local conflict. There are undeniable regional dimensions and influence that are perpetuating the conflict. And also what is happening now, the massacre of civilians is not related to the conflict, because the army, which is at war between, it has been at war with the RSF since April 2023, has withdrawn from Darfur. So what the RSF are doing to civilians has nothing to do with the conflict. It's important to be reminded that the survivors are ready and willing to continue playing that role, because the message that they are sending to us is very, very simple, that they will never trade justice for any short-term relief. Because for them, there can be no justice without peace, and vice versa. Thank you. I will stop it here.
Thank you, Ilaria. Thank you for this mostly disturbing information about Sudan. And it looks like at the first glance that conflicts in Ukraine, the war in Ukraine and what's happening in Sudan are symptoms of maybe the same or similar issues with international accountability mechanisms for prevention of atrocity crimes that probably were not effective enough to stop the conflicts. Now from Sudan to Colombia, I would like to invite Maria to the floor to share her perspective about what is happening in Colombia.
Thank you very much, and good afternoon or good morning for everyone. Thank you for this opportunity to share the Colombian experience and our relationship with international mechanisms like the ICC and the OTP. Let's start saying that reaching an agreement about the need to hold perpetrators accountable to victims and society requires a long process of discussion and debate about the state's obligation to investigate, prosecute, and sanction serious crime, the importance of victims' rights in the contemporary world, and the need to guarantee these rights to the greatest degree possible to reach a legitimate and sustainable agreement, and providing legal certainty to the different perpetrators of serious crimes to ensure their effective reintegration into society. This has had a direct impact on the legal design of peace agreements and transitional justice mechanism in Colombia. In 2012, and before the beginning of the negotiations process in Havana between the government and the FARC guerrilla, a constitutional reform was approved, which created a legal framework for peace. This framework established that the transitional justice instruments agreed between the negotiating parties will be exceptional and will pursue the prevalent purpose of ending the internal armed conflict and achieving a stable and lasting peace with guarantees of non-recurrence. The reform also introduced key principles in the Constitution that allow the transitional justice mechanism to focus on the criminal prosecution of those most responsible for the most serious crime, while guaranteeing the rights of victims to the highest degree possible. The most recent Colombian peace process is a milestone in the history of the country's internal armed conflict. It is historic because after more than 50 years of conflict, the government of Colombia was able to negotiate a peace agreement with the oldest and most powerful guerrilla organization in the country, the FARC. A conflict as complex as this one, with multiple actors, interests, atrocities committed, and victims, could only produce an equally complex peace agreement that is challenging for the Colombian society. The agreement acknowledged both the causes and factors that explain the conflict and its consequences. It also mainstreams the centrality of victims because it recognized that a peace process today is not possible if victims' rights are not seriously considered, taking into account victims' demands and the understanding and acceptance that the state has obligations in the fight against impunity that it must fulfill. In order to tackle the legacy of the atrocities committed by all actors to the conflict, the negotiators designed a comprehensive system of truth, justice, reparation, and non-recurrence that draws on the lessons from previous transitional justice processes in the country and on comparative international experiences. It is the first time that two parties negotiating the end of an armed conflict jointly designed the mechanism by which they will be held accountable for the crimes they committed. Let's address the peace process negotiated under the ICC scrutiny. The 2016 peace agreement was the first to be negotiated under the close observation of the ICC's Office of the Prosecutor, which has opened a preliminary examination in Colombia in 2004. The transitional justice design was therefore shaped from the outset by Colombia's obligation on the Rome Statute, to which it has been a party since 2002. As a result, Colombia's comprehensive system for truth, justice, reparation, and non-recurrence was conceived to meet international standards while allowing room for political negotiation. Rather than offering unconditional amnesties, Colombia adopted a differentiated accountability model. Those responsible for serious crimes must tell the truth, acknowledge responsibility, contribute to reparation, and accept restorative sanctions involving restriction of liberty, but not imprisonment. This is based on a broad concept of justice that includes criminal, restorative, and truth-seeking mechanisms in order to guarantee victims' rights to the greatest degree possible. It should also be mentioned that although it is a domestic tribunal, the special jurisdiction for peace created by the peace agreement has the authority to directly apply international law and prosecute Rome Statute crimes, even when they were not codified in national law at the time of commission. However, the interaction between domestic actors involved in the peace negotiation and the OTP was not always smooth. Tensions emerged, for example, around case selection and non-custodial sanctions. The OTP initially took a stricter view of justice, while Colombia's Constitutional Court upheld more flexible approaches, most notably in 2013 ruling that endorsed alternative sanction and case selection. Over time, this led to an evolution of the OTP stance from skepticism to acceptance of diverse forms of punishments and case selection. Deputy Prosecutor James Stewart's 2015 remarks in Bogota, recognizing statewide discretion in sentencing, and the OTP's 2023 report referencing the Constitutional Court's principles as guidance for assessing the sentencing framework exemplify this shift. In 2021, the OTP and the Colombian government signed a cooperation agreement extending engagement beyond the closure of the preliminary examination. This arrangement aligns with the prosecutor's 2024 policy on complementarity and cooperation, emphasizing technical support, exchange of good practices, and joint learning. However, the agreement also reserved the OTPs the right to reassess the situation of Colombia if guaranteed due to a change in circumstances. As the Special Jurisdiction for Peace enters its 8th year, it faces the challenge of delivering on a restorative vision that remains largely uncharted in international practice. The extent to which it succeeds and whether this will provide satisfactory to both victims and the ICC remains to be seen. What could already be said, however, is that the Colombian experience signals an important shift. It demonstrates the possibility of engaging constructively with the ICC while prosecuting international crimes at the domestic level without hybrid or internationalized mechanisms taking center stage, thereby contributing to the greater national ownership of justice. Considering that the preliminary examination was opened by the OTP in 2004, the ICC was present in Colombia well before the peace agreement with the FARC and the establishment of the Special Jurisdiction for Peace. As such, the Special Jurisdiction added a new dimension to the OTP assessment, which ended up encompassing 3 domestic judicial mechanisms: the ordinary justice system, the Justice and Peace Proceedings created in 2005, mainly to investigate the crimes committed by former paramilitaries, and the Special Jurisdiction for Peace. Consequently, it should be noted that the Special Jurisdiction for Peace was not the sole factor behind the OTP's decision to close the preliminary examination in 2021. Rather, the combined effect of the 3 judicial mechanisms addressing various cases of interest to the OTPs was crucial. The Special Jurisdiction for Peace did, however, play an important role. After the signing of the peace agreement, the OTP observed that the establishment of the Special Jurisdiction for Peace, quote, merited special attention in view of its objective to address the rights of victims of the armed conflict to justice and truth, as well as to meet Colombia's international obligations to ensure accountability for grave international crimes. End of quote. In conducting its complementarity assessment, the OTP applied a 2-step test. 1, whether national proceedings were taking place that sufficiently addressed potential ICC cases, and 2, whether such proceedings appear to be undermined by inability or unwillingness to carry them out genuinely. Key factors that appear to have motivated the closure of the preliminary examination under this test include: the OTP received a significant amount of information about the domestic proceedings that allow it to exhaustively apply the 2-step test. The ongoing and progressively advancing nature of domestic proceedings, together with clear prospects for prioritizing investigation in cases relevant to the OTP, were central to its assessment. The Special Jurisdiction for Peace played an important role in this regard. By then, it had opened its first 7 macro cases and begun preparatory work for additional cases, developments the OTP described as significant. The OTP also noted that domestic jurisdictions were prosecuting conduct in ways that sought to identify patterns of criminality, expose underlying policies, and situate individual acts within broader systematic context. It further noted that judicial authorities were addressing allegations involving those who appeared to bear responsibility at the highest command levels. And finally, the OTP considered that these advances showed that Colombia met the threshold of genuineness required under complementarity. It therefore concluded that it found no indication of unwillingness or inability to conduct genuine investigations and prosecutions in line with the criteria set out in Articles 17.2 and 73 of the Rome Statute. Thank you so much for your attention.
Maria, thank you so much. I was actually reflecting that the powerful remarks from Dmytro, Ilaria, and you, Maria, really show that the contexts, which seem to be so different in their nature and geography, have so much in common, both in, sadly, the patterns of impunity, but also in the commitment of survivors to catalyze transformation even while the atrocities are still ongoing. And it's also remarkable that in terms of complementarity, it was actually a Colombian jurist who was the special advisor to the ICC prosecutor on the policy on complementarity. And I can just give a sneak peek that he has agreed to contribute to our future webinar. And I think it also shows so much how we can share the experience from the domestic processes to help international institutions and not vice versa. Colleagues, we now turn to an interactive Q&A session. Yuri, it's still a work day in Ukraine, and Yuri, unfortunately, would have to leave soon. So if you don't mind, I will raise the question already posted in the chat for Yuri, and if possible, Dmytro, I will also ask you to follow up on that, on Ukraine's efforts, vision, and actions to prosecute crimes against or affecting cultural heritage. Yuri and Dmytro, over to you.
If you don't mind, I could start. I briefly answered in the message, in the messenger. So the issue is that within the war crime department, since previous year, it was established a special team of prosecutors which are focusing exclusively on crimes against cultural heritage. So it's a special team of prosecutors who are well trained by UNESCO and by other partners, and who work with Ukrainian NGOs who have a specialization on cultural heritage, international partners, and I'm sure that there would be results, because during this war, the damage to the Ukrainian, not just Ukrainians, all over the world, crime, the cultural heritage is extremely high. That's why I really believe that we would manage to prosecute both in Ukraine, and I believe that maybe ICC would also have a look at this specific sphere as well.
Yuri, thank you very much for being with us. I understand that you might have to leave. So if you do, thank you so much again for joining. If you can stay over longer, we would be overjoyed. Otherwise, Dmytro, over to you. You worked so much as a legal practicing lawyer and academic on the cultural heritage dimensions of Russia's aggression. So what's your take on that?
Katerina, just the last point from my side is before leaving, I really need to run, but I see the last question, if you don't mind, regarding the Interpol, because it's an extremely interesting question. I would be very diplomatic, let's say, but I could say that Ukrainian Interpol office, because we have a National Bureau of Interpol, is doing its best to change the approach of Interpol towards war crimes. I could also say that there is slight hope that Interpol would change its perception, because if Interpol would operate as we as Ukrainians wish to, so it would definitely help us significantly to trace war criminals all across the world. But we are in negotiations with this institution for the several years, and there is a slight progress. But it doesn't mean that Ukraine can't use other instruments, like Europol, for example, or other channels. You know, there are a lot of channels between law enforcement which are extremely wide used by Ukraine to share the information with other jurisdictions, to get the information, to notify each other about the movement of potential war criminals across the globe. That's my answer. But guys, it was a great pleasure to be with you. Thank you so much, Katerina, for inviting, and to all panelists as well. Have a good day, and I wish you safe day, evening, and wish all of us peace.
Thank you very much, Yuri, for your work, for finding the time, and have a safe evening.
Thank you so much.
Thank
Bye.
you. Dmitro, over to you. Thank you.
Thank you, Katerina. So after Yuri provided us with understanding of institutional framework of responding to cultural heritage crimes, I'll probably reflect on a couple of more legalistic issues and technical issues that have to do with the qualification of crimes against cultural heritage. So the international criminal law and international humanitarian law provides us with several options how we can portray or qualify the acts against cultural property. We can divide the list of those acts into two categories. The one would be the category that we can call the attack-related offenses against cultural heritage, and the other would be the non-attack related offenses. So let me start with the later. When we see the acts that do not can be characterized from the international humanitarian law standpoint as attacks, for instance, that might be pillage or demolition of some cultural heritage, like it happened in Timbuktu, for instance, or appropriation of museums or museum collections, or something along those lines. The proving of such crimes is more or less easy. I mean, nothing is easy in our field, but at least you have quite a good chances if you at least know about the fact of demolition of the building or relocation of the collection or something like that. You have good chances to build a somewhat strong case against the perpetrator of the crime. But if it comes to the attack-related offenses against cultural heritage, for instance, the use of missiles or rockets or drones or whatever else against the cultural institutions, cultural buildings, then the task would be extremely complicated. Because on top of what you usually have to prove with the attacks on civilian buildings, meaning the fact of the attack and the knowledge of the perpetrator about the protected status of that building and the intent of harming that particular civilian building, you have to also prove that the perpetrator knew about the cultural significance of that same building. So that's kind of another layer to usual work that prosecutors and investigators would do in the cases of attacks against civilian objectives, civilian objects. So my response, my point is that with attack-related crimes, in very few circumstances, we can actually say that the war crime of attacking cultural heritage, cultural property happened. I would say that the best chances with that category would be in the situations when there are continuing and repeating attacks on the same cultural area or the same place where we have the concentration of cultural property. The good example of that would be Odessa city and the UNESCO inscribed center downtown of Odessa city. So Russia continuously attacks that area, probably aiming at port facilities, maybe some other installation that may be seen as military objectives, but constantly it causes harm to civilian, to cultural heritage in the downtown Odessa. And that might give us a clue to the mindset of those who plan and perpetrate those attacks. The mindset might be that they just ignore the potential harm that might be caused to the cultural heritage in Odessa. And that may lead us to the conclusion that the crime, the attack-related crime against cultural heritage is happening. So that would be my technical response. We have good chances with pillage, with maybe destruction, less so with the attacks against cultural heritage.
Thank you, colleague. Thank you for such comprehensive responses to this question. I would like to ask, to pose this next excellent question to Maria, actually. How does the special jurisdiction for peace balance the demands of justice, truth, and reconciliation while ensuring accountability for serious violations of international humanitarian and human rights law? It's a question from the chat. And yeah, here you go.
Thank you. Yes, well, this was a very, very difficult discussion during the negotiation in Havana, because we have to find a way to balance the need of justice for the most serious crimes, but at the same time, we need to create the environment and conditions for a lasting peace. So this was the balance that we need at the time. Finally, what we designed was a mechanism that include mechanisms to guarantee that people who were or perpetrators who wants to have the treatment in the HEP have to tell the truth, acknowledge responsibility for the crimes committed, and to contribute to the reparation of victims. If one person can comply with these responsibilities, at the end they can have he can have a restorative sanction that not imply imprisonment. So the balance was the highest truth and acknowledgement of responsibility possible, and on the other side, benefits that include this sort of restorative justice approach for sanctions, in order to guarantee that these people can be reintegrated into society, but acknowledging the responsibility their responsibility and participating with victims in the reconstruction of territories and to repairing the damage they caused for victims and for society. This was the balance that we found.
Thank you very much, Maria. Again, because Ukraine is affected by an external aggression, I still think this example and approach is so informative for us, but for a particular type of cases, which are a very big in number, the collaboration cases, because it's largely our own citizens, and the current criminal justice approach to collaboration in Ukraine, sadly, is not the most sustainable. And I think here the HAP's experience of engaging the alleged perpetrators in the truth-telling, in paying reparations and rebuilding the community might be something instructive for us. Thank you very much. Ilaria, I have a question to you. You mentioned the attempts at the peace process for Sudan, and you also mentioned how gender does not surface enough there. And that with respect to another context in Syria now as well, we are hearing how unfortunately gendered considerations are not as much in focus as they should be. I'm wondering, how do you see this being in short in the context of Sudan, and what do survivors amid all other needs and facets of victimization think about the need of prioritizing gender considerations?
Thank you. A very burning question. So unfortunately, in current peace processes, they're extremely limited. Survivors are not invited at all, so whether male or female. It's really elite, the influential countries in the region who and plus the US who are leading this process. So the current peace process is one of the most limited in terms of participation that we have seen. Women have really borne the brunt of violations disproportionately. They have been targeted specifically. Videos also of the violence that they have endured. They have been posted to humiliate them and to scare other women. This has happened during the war that started more than 2 years ago, but also a few years before. So what we have been doing to try to also raise awareness among the civilian coalitions about the importance of introducing a gender dimension into their work is to have, on the one hand, mainstream the gender aspect in all our activities, but also to have dedicated moments in which we specifically talk about that dimension. And that include women and men, of course, because we need men to champion those ideas. And that so is across the board. What Sudanese told us that they need more than ever is also a space to rediscuss the social contract on more inclusive terms. And that means also from the gender point of view. They need a space, a safe space to elaborate their vision so that when there will be an inclusive peace process, they will know what to push for. The peace processes are also very technical in nature. There has been a peace process in 2020 that did include a lot of provisions on transitional justice, but there were a lot of provisions that were actually did not ensure for a credible and fair transitional justice process, and also deadlines were really unrealistic. So it didn't help. So there is a level of technicalities that need to be looked at to make sure that the process is viable and genuine. We look at gender also in our work on arts, given the importance that arts has to promote a sense of identity. Again, being Sudan the largest displacement crisis in the world, arts is really the moment in which survivors can enter a different dimension and feel united and coalesce around a certain ideal of justice and feel at home in a way for a moment. And we have done it also with journalists in our training with journalists to promote gender-sensitive language. And also in the way they do documentation, how can we promote the gender justice aspect? So it's really an angle that we use across the board in all countries, particularly in Sudan, where women have been victims also of discriminating legislation that Sudanese have tried to amend during the short transition between 2019 and 2021, but then the military coup overturned all those very promising changes.
Thank you, Ilaria. I would like to ask a question from the chat. Could someone talk about the incorporation of open source evidence, drone footage, satellite imagery, or even social media posts into investigations and future justice initiatives? I'm thinking about the plethora of social media documentation of war crimes in Ukraine, but also in Sudan. Dmytro, Ilaria, would you like to answer this one?
Dmytro, would you like to start? I'm happy to follow.
Go ahead, Ilaria. I will add a couple of points after you.
Sure. So this is, yes, a very kind of for us, it's a field that ICHJ has been working on for a few years now. And what we're also trying to promote is not just training on these aspects to understand how to collect open sources safely without exposing human rights advocate, and what kind of level of what standards are they looking for? Clearly, as was mentioned before, standards of evidence for trial require a certain quality, and it's always advisable to try to collect the highest quality possible of evidence so that they can be used for trial, but they can also be used to advance other transitional justice processes such as truth seeking and others. So it's something that we have been working on quite a lot, and our next let's say challenge for us is really to try to build community of practice among experts. They have become experts, so not just from Sudan but also from other countries, so that they can really learn from each other's experiences and understand. Also, not to feel alone. It's something that it is an aspect that should not be underestimated, because being a human rights advocate can be a very isolating experience, given the need to cross-check the trustworthiness of any person that they speak to. So having a safe space where they can really grow and learn, and in the tech, not just in the technical aspects, but also seek support, is something that should not be underestimated. And I will say another one last thing is clearly documenting with open sources, with videos that are extremely graphic, is very distressing. So something that we always do is to accompany that work, those trainings, with mental health support. And also we incorporate sessions on resilience to make sure that there are also healthy coping mechanisms for advocates, because again, this can be extremely heavy on their mental health. I'll stop it here.
I will probably start where Ilaria left it. Indeed, this secondary trauma that she mentioned is something that is not talked enough when it comes to open source data, including data from social media. We face it ourselves, that some of the information in open source, some of the information that basically dehumanize people who are being targets of atrocity crimes, is quite strong. I mean, the effects on the people who are doing this work is quite strong. And without proper support, psychological support to them, it's complicated to expect that the secondary trauma won't come sooner or later. I would say that Truthhounds also has quite a large team of investigators, and that's one of the important streams of Truthhounds' work, to collect digital evidence and analyze them. To make the evidence acceptable in different various jurisdictions, we use the rules that were codified in the Berkeley Protocol, for instance, to basically secure the storage of the evidence properly, but also to record all the steps that we do to to find the evidence and to collect it, to properly archive it, also properly for the sake of different jurisdictions. And maybe responding to the core of the question on how we can integrate actually this evidence into the actual proceedings, I would say that the answer will very much depend on the jurisdiction we are talking about. For instance, Ukrainian jurisdiction is very strict on what evidence are acceptable and what evidence may be brought in front of the court. And this strictness of Ukrainian criminal procedure regulation leads us to the situation in which you have to be really creative to persuade either investigators or prosecutors or judges, especially judges, that the evidence collected from the open source has some value or equal value to some more traditional types of evidence that judges, for instance, work in the ordinary criminal cases. But when it comes to ICC, for instance, they are well versed in using open source, and they know how to distinguish between good or properly collected open source evidence from poorly collected. And if the evidence is preserved in a proper form, then the ICC would certainly go for it and use it for corroborating some of the other information that they have. Again, when it comes to UJ, to different jurisdictions in Europe or elsewhere, it also will depend how what is the internal internal practices in that particular country with regards to open source or evidence collected from the internet. So if those practices are more allowing, or if they are friendly towards OSINT evidence, then the chances are that properly collected evidence would be integrated into the criminal proceedings. So that would be my addition to what Ilaria was discussing.
Thank you very much, Dmytro and Ilaria. Just, if I may, before turning to the next question, a small add-on. The mass spread of atrocity footage by the Russians on very well and easily accessible social media and other web channels have been qualified as an alleged war crime of outrageous upon personal dignity, most recently by the UN Commission of Inquiry. And I think it's a very important finding, because it's an assault on the person who is in that footage, but it's also the massive impact on their families and wider on persons, well, in Ukraine and actually beyond Ukraine, because it's a strong demonstrative discouraging message. Like, if you join the fight, this is what's going to happen to you. So thank you very much for asking that question, and thank you very much for your very multifaceted responses, because I think it's really not just about the using open source evidence in case design and case submission, but it's also thinking how it impacts the wider civilians and the wider population. Maria, if I may combine two questions on Colombia for you, please. There is a question as to how the civil society has been engaged in the design of the peace process and its transitional justice dimension. And an adjacent question is how the Colombian civil society is happy with the progress of the implementation, given still the ongoing hostilities, and given that there are even calls for the ICC to re-engage in the situation because of not the perfect implementation of the peace plan and its transitional justice dimension. Over to you, Maria.
Thank you. Yes, the civil society participation was crucial in the design of this integrated system of truth, justice, reparation, and non-recurrence. Actually, victims were in Havana during the peace negotiation. They have the opportunity to present their cases and reflections and proposals in the negotiations, and they have a very useful conversation with the parties to the negotiation, with FARC and with the Colombian government. And I think this participation had a great impact, because it allowed the parties to understand the different dimension of the damage caused by the internal conflict in communities and in victims. And at the end, the final design of this system included a lot of recommendation and reflections and proposals of Colombian civil society. And from the beginning of the special jurisdiction for peace, victims are participating in all the proceedings. But at the beginning, as well, civil society had the opportunity to present reports on different cases that were very useful for the judges to prepare the cases and then to open the cases. And the reports were included information about different crimes, different situations in different regions. So it was very, very useful for the special jurisdiction for peace in this first stage of its work. And they're still participating in the proceedings, and victims are very vocal and very committed with those proceedings in the special jurisdiction for peace. And about the second question, or the second part of the question, we have to take into account that right now Colombia is a very polarized society. And from the beginning of the peace process, I have to say that the half of the society was against the negotiation, and the other half of the society was supporting the negotiation. And when we have the final agreement, we have the same situation. We have a plebiscite and we lost. And I say we lost because I am a supporter of the peace agreement. But the people who were against the peace process and the peace agreement at the end won the plebiscite, and until now we have this same picture. Some of the victims are very, I mean, maybe not happy at all, because we are ongoing. The process is ongoing. The HEP the special jurisdiction for peace takes 8 years to have the first two judgments. It was a lot of time, but these judgments are very important because it's the first time that the Colombian judicial system is saying these crimes were committed. The most grave crimes was committed, crimes against humanity, war crimes against during the conflict, committed by FARC, but also by the military forces. So it's the first time that a national judicial mechanism is saying that very clearly. So for many victims, it's a very important message, because the state is acknowledging for the first time in this judicial system that war crimes and crimes against humanity principle were committed during the conflict. But of course, we have a lot of work to do, especially to guarantee that those restorative sanctions can be applied in the way that the agreement designed it. And it's a very difficult moment because we are in the middle of an election process. So the peace agreement and the special jurisdiction for peace and the issue of impunity is again in the middle of the political debate. So in this scenario, it's very difficult to put aside the political discussion and to try to acknowledge what the HEP is doing, or the special jurisdiction, the jurisdiction for peace is doing well. So people who are very committed with the electoral process are still saying that this is impunity. The no imprisonment is impunity. But other people and victims especially are saying what we need is not only to see people in jail, but what we need is reparation, truth, acknowledgement of responsibility, and for us, this is justice. So we have the two positions right now in our society.
Thank you, Maria. I think you very wonderfully summarized what transitional justice is and why it includes other pillars in addition to accountability, and why other pillars are so important in achieving peace and justice that would be sustainable and prevent future violations. Now I would like to ask the next question to Dmytro. It's also a question from our chat. Dmytro, does Ukraine need a truth commission, and who, in your opinion, should determine its mandate and powers?
I'll probably start with saying that the context in which the discussion around Truth Commission is unfolding in Ukraine is very different from other contexts, like in South Africa, for instance, or in Colombia, or in other parts of the world. And the reason for that is that we don't have an internal conflict, but an international one. And also, the conflict started not from some mutual steps towards it, but from very black and white violation of the peremptory norms of international law, which makes it much harder to even start the discussion regarding the reconciliation and truth-seeking. But that's only if we wrap this discussion around the issue of reconciliation with the Russian state or the participants in the armed conflict from the Russian side. There is a very different side of the story that is also part of this war, and that's the story of Ukrainian civilians who were left on the occupied territory, including those who had to survive somehow on those territories, which means to at least on some basic level to cooperate with the occupation administration and occupation authorities. So this means that we can start talking about reconciliation, truth-seeking, etc., from that very point, from the point of bringing together Ukrainians who were divided by the front line, who didn't choose to become a part of this war on the Russian side, but who found themselves in the circumstances where they had to survive somehow, and where they were fully immersed into the propaganda about the Nazi character of Ukrainian political regime. So I would say that in this, from this angle, there is space for discussion on the Truth Commission or reconciliation or other means traditional for transitional justice. As for who should start, who should decide on the Truth Commission architecture and the decisions and what decisions they can render and what will be the force of that decision, I would say that it should be a very broad dialogue between the survivors communities, between the Ukrainian civil society, which is quite strong, with the inclusion, of course, of state officials, but not with the majority of states. So the state of representative should not have the golden vote in this discussion over the Truth Commission. So I would say that at least half of the decision power should be on the side of civil society and survivors, potentially also other stakeholders. So that would be my decision. I understand that it's not concrete enough, but that's all I can say at this point of the conflict.
Thank you very much, Dmytro. Thank you very much, Ilaria and Maria. I think through today's webinar, we have indeed neared the aim of our whole webinar series. We really wanted to show how many shared human, legal, contextual dimensions are there in the situations which seem to be so remote and so different. So thank you very much for illuminating us and for really bridging the knowledge as much, crucially, as the hearts. Ina and I would like to proceed with announcing our future webinars, which actually intersect in topics with much of what we've raised today. So Ina, over to you to speak about.
Thank you, Katerina, and I would like to also thank all today's speakers for your time and your knowledge that you shared with us, and hopefully it will help us to inform our policies and practices in Ukraine. As Katerina and I mentioned, today's webinar is one in the series of events dedicated to transitional justice. So next Monday, I believe it is, on the 10th of November, we would like to invite everyone to join another webinar, this time dedicated to the experience of Sierra Leone in addressing consequences of the conflict and building the framework of truth and justice in the country. You can find registration on the website of the Ukrainian Bar Association, but also in social media of all co-organizers of this event. And as a reminder, this series is organized by the Ukrainian Bar Association, the International Center for Transitional Justice, Truth Hounds, and Kyiv Mohyla Academy. And if you cannot find a link for some reason, please let us know. It will be published right after today's webinar. But if you have any questions or need additional information, please let us know. And I would like you to follow us. More events are yet to come, and we will be happy to share more experience and more information with our audience. Thank you, and I suppose we wish you a safe day, safe evening for those of you where it's evening, and we appreciate having so many wonderful experts, partners, people with us today.
Thank you very much for the invitation. Thank
Thank
you.
you.
Thank you very much,
Bye.
dear colleagues. Stay
Bye.
safe. Thank you.
Thank you, colleagues.
See you on
Bye.
Monday.